Hello, everybody. It's Dave Neal, stand-up comic and host of Bachelor Nation News and the Rush Hour podcast, available twice daily. We have an update here in the Bachelor Clayton Echard paternity scandal. It's not extremely interesting, but I was actually going to make a video anyway today just to say, hey, guys, I'm still around. The case has slowed down, but sunlight's the greatest disinfectant, and we pledge to give you every inch of this case, because I'm telling you this right now. When we let our foot off the gas, we're going to wake up one day, mark my words, we're going to wake up one day and she's going to have a book, Laura Owens, that she's writing that completely rewrites the story. It's going to be one of those O.J. Simpson style books that comes out that does, you know what I mean? So we know that's going to happen. We're here to cover everything, but it's a little bit of a stalemate as we wait to hear from the judge who is going to decide whether or not there was an ethical issue that'll make this whole case be thrown out. So Clayton Echard, of course, the never father of Laura Owens' unborn twins, had the judge side with him that there was a pattern of abuse here and repeated offense, similar stories, whatnot, thanks to the past, 8 fetuses she claimed to have had run through her. Either way, that judge is being accused by her attorney of being unable to talk, and we'll have to see what that judge's boss says. Her attorney, Jingy, we're calling him, short for Jingress, is being I hate to use the word Karen because there's plenty of fine Karens out there, but he's asking to speak to the manager. Who's managing this judge? Either way, we have an update. We're going to get to it right now. So the update is he posted, and again, he just has a way to just piss people off. It's really a skill. I mean, the way he can troll people so easily. He should really be a YouTuber, not a lawyer. He's really in the wrong profession. So he says, only one person asked for this copy, but just in case you don't have a job, and the only way you can make money is by sitting and reading someone else's work on YouTube while slamming them and boasting about what a genius you are, a gift. Oh, well, thank you all so much for by the way, Gingras gives these motions away, but at the same time, we've got people that will go out and get them for us. So he's almost giving us a gift of free air. It's like, all right, other people can breathe that air and will provide us the motions, but if you want to hand them over, sure. Who is he talking about when he says reading someone else's work on YouTube? It's really either me or Megan Fox or one of the other amazing, talented folks who've been covering this case. There really are a bunch. But how rich of him to say, in case you don't have a job, my man, the people that are reading and learning about this case and making YouTube videos are doing their job, sir. You represent a client, Laura Owens, who would only benefit from nobody talking about it. We are shouting it from our proverbial rooftops because we need the world to know what is going on. And you might say, why? What's the big deal? Of course, Laura's big thing is saying, why does this crazy YouTuber care so much about my sex life? Look, I don't know what gets you off at night. Maybe thinking I do care about your sex life. I don't, okay? Married man, I'm good. I got a baby. I got evidence of a sex life, at least at one time. But my point being is that I don't care about her or her attorney. I care about the truth. I care about protecting the truth and not rewriting the truth. So anyway, I'm not slamming him. I don't think I'm a genius. I think anybody who thinks they're a genius is probably an idiot. I know my blind spots. I'm not good with the law. I'm good with my intuition and sharing it and I guess prosecuting my point. I think that's why we've built up a little bit of an audience here. I think he might be jealous at the actual levels of income YouTubers do make. They are one-man broadcasting shops, one-man cable stations. You know what I mean? Like a good YouTuber makes a hell of a lot of money. $1,000 a day. 8, 10, 15, 25,000 bucks. A good YouTuber, I'm not saying me, but a good YouTuber might be really crushing it. And it's not to exploit Laura. It's because she exploited these men that people want to make sure they right the ship. And I think that is fair for people to do. She allegedly exploited these men, although it appears as though the judge has, granted immunity to anyone who wants to make the assumption that she exploited them. In the matter of Laura Owens and Clayton Echard, here's the petitioner's response objection to respondent's application for attorney's fees and costs. So essentially, Woodnick, Clayton's attorney, says, all right, we want $150,000. Here's what we charge. The response will share, I guess, information that says, well, you shouldn't charge that much. Either way, if, according to the court, Laura's going to have to pay a lot of money, whether it's $80,000 or $150,000. The point may be moot because no one actually thinks she's going to pay. Repo that horse, baby. Introduction. This case is currently in a difficult and unfortunate posture. Yeah, it sure is. The only posture she was in since May 21st that's difficult and unfortunate. As a result, this brief is almost certainly futile because no matter what is argued herein, Clayton has either already won the issue or he has already lost. We just don't know which it is yet. Well, we know the judge ruled that Clayton won, but now, of course, we'll wait for what the manager says. As the docket reflects, as of today's date, there are 2 other pending unresolved matters. Laura's notice of change of judge for cause and Laura's motion for a new trial. Both filings raised the same central issue, misconduct by the trial judge, which violated Laura's right to a fair hearing. Based on that issue, among others, Laura has asked for an order disqualifying the currently assigned judge and ordering a new trial. These requests are essentially overlapping. If the disqualification request is granted, a new trial is probably automatic, thereby mooting the current fee application. On the other hand, if the disqualification request is denied, the outcome of Clayton's fees application is a foregone conclusion. Due to this unusual posture, this brief is unlikely to have any effect on the outcome of the litigation, except to the extent any of the issues may need to be raised later on appeal. Accordingly, this brief will present Laura's arguments in an abbreviated manner. There ain't nothing about her and her lawyer that is abbreviated. Discussion. While considering the issues of fees, it is important to stop and note the context. This case involved a petition to establish paternity. When such a petition is filed, there are only 2 possible outcomes. Paternity is established or paternity is not established. Although the parties vigorously dispute the question of whether Laura was ever actually pregnant, 2 key facts are entirely undisputed. Both Laura and Clayton were pro se from the date the action was commenced on August 1st until mid-December 2023. Laura moved to dismiss this case with prejudice on December 28th. This timeline is crucial to understanding the fee issue. So the relevant dates are depicted in the diagram below for clarity. Oh, they have a diagram. We love a good diagram. There it is. There's your diagram. I mean, it's not the most complicated diagram. August 8th, December 12th, Woodnick appears. A couple weeks after, isn't it funny? 2 weeks after Woodnick appears, and she's like, let's settle this. We need to move to dismiss this. And Woodnick and Clayton are like, no. We're just getting started. We're having fun. Remember, Laura, when you accused Woodnick of those crazy things with that previous client? Remember that? Well, Daddy Woodnick wants to partake here. And is it personal? Well, I can't speak for anybody else, but wouldn't it be? Wouldn't it be? And personal is the reason why you might cover something for free. Like, is this personal for Jingy? I think so. I think it's personal. I think that's why he's probably not getting paid. So unlike these YouTubers, and he can let us know by sharing his pay stubs, but unlike these YouTubers, some of us actually do have a job. It's not just arts and crafts putting together diagrams. You know what I mean? As this diagram shows, it is an undisputed fact that between point A, commencement of the action on August 1st, and point B, when Clayton's counsel first appeared on December 12th, neither party incurred any legal fees because both parties were pro se. Despite this, Clayton's fee application shows substantially all fees he is seeking were incurred between points C and D, which, as now explained below, was completely unnecessary in a matter of law. Also disputed are 2 other key facts. First, prior to filing a motion for leave to amend on December 12th, Clayton's counsel, Greg Woodnick, violated Rule 9C of the Rules of Law, Family Law Procedure. Mr. Woodnick violated Rule 9 by bringing a motion without making any attempt to meet and confer with Laura to determine her position. This leads to the second key fact. Immediately after Mr. Woodnick appeared, Laura's first step was to file a motion to dismiss. Yeah, you know why she filed a motion to dismiss? Because it was getting real, and she realized her private bullying could no longer happen. But as a matter of law, the dismissal motion terminated any right Clayton may otherwise have had to seek fees after that date. Put differently, Clayton's present fee application seeks an upward of $154,000 in fees and costs incurred for the purpose of defeating Laura's petition to establish paternity by proving she was not pregnant. But Laura's motion to dismiss unequivocally admitted that fact. The second line of the pleading stated, petitioner is not now pregnant with respondent's children. So that's all she had to do was say she wasn't pregnant, and she can just rewrite how the whole story goes. Viewed in that context and putting aside his counsel's violation of Rule 9C, if Clayton was entitled to any fees at all, which he is not, the only time period involved would be between points B and C, from December 12th, when Mr. Wittick first appeared, until December 28th, when Laura moved to dismiss. No fees may be awarded prior to point B, because Clayton had no fees prior to then. Well, here's the deal. If she was so much in the right, then she would have won the case on June 10th, and he would have to pay her bills. But she lost that case, right? So, again, all she had to do was be in the right. She was not. She was in the wrong. Mr. Woodnick was required to meet and confer with Laura if had complied with that obligation. He would have learned by making a single phone call that Laura was no longer pregnant and that all paternity issues in the case were moot. So to recap, even assuming Laura was never pregnant at all, it is undisputed Clayton did not incur any fees between points A and B. It is further undisputed that Clayton would not have incurred any fees after point B if his counsel had simply complied with Rule 9C by contacting Laura and asking for her position. Mr. Wittick cannot and should not be rewarded for ignoring a mandatory procedure rule in this matter. Clayton is not entitled to fees for litigation, a moot claim. In her motion to dismiss, Laura explained she was no longer pregnant and thus any paternity establishment issues were moot. It is well established that courts cannot decide moot cases. All right, well, I guess Clayton argued it wasn't moot. To boot. Here it is undisputed Laura admitted as of December 28th she was no longer pregnant. Had Clayton's counsel complied, as he was mandated to do, Laura would have made that admission even earlier. Clearly, as a matter of law, Clayton is not entitled to recover $150,000. All right, let's ask the internet. Had Clayton's counsel complied, Laura would have made that admission earlier? I mean, didn't Laura just lie and say she was like absolutely pregnant? So Laura is saying, hey, if he just played by the rules, he would have known I wasn't pregnant. Days earlier, she was talking about being pregnant, right? Can we get a graph? He's trying to play the graph game. Can we get a graph? We need our own graph. Somebody, fly in a graph. They also say fees cannot be awarded for tort-based claims. The record in this case is clear. Laura learned she was no longer pregnant in mid-November, and after making that discovery, she filed nothing further in this case. Due to the lack of case activity on December 4th, court administration issued a notice placing this matter on the inactive calendar and stating the matter would be dismissed in early February if no further action was taken. Had no further action been taken, this case would have been dismissed without Clayton incurring a single penny of legal fees. Yeah, and then she would have made a TEDx talk. She would have, gone on Jezebel. Are they still around? She would have, talked about how the Bachelor was, blah, 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 blah. Clayton had every right to prove she was never pregnant. As has been explained in other pleadings, the family court had no subject matter jurisdiction to decide non-paternity tort claims such as fraud, defamation, or malicious prosecution. However, even if the court had jurisdiction over these tort issues, court cannot award attorneys' fees. I guess the argument is whether or not it's a tort issue. I'm not a lawyer. I'm not a genius. Here, Clayton's allegations against Laura sound in tort. They accuse her of committing fraud and other intentional torts. Well, look. Even if Clayton is only suing for legal fees, he can still say she's committing fraud. You know what I mean? As such, even if the family court had jurisdiction to adjudicate such claims, which it does not, Clayton cannot recover fees for litigating those claims because the only claims remaining after mid-December were counterclaims that sounded in tort. By the way, I haven't read this before, so I don't have any strong opinions about any legal strengths that he has here, but even he said at the beginning that this is relatively, a waste of time. Clayton failed to show his fees were reasonable. All right, now it gets interesting. And I'm sorry, I have an actual throat issue today. I don't know what it is. Maybe Laura can send me some lozenges. But I'm just like, I can feel it coming on. Clayton, Laura, that was a sarcasm. Don't send me lozenges. She's going to show up at my door. I got you lozenges. No, Laura, we're not friends. Leave me alone. I just thought we'd be friends now. It's all a bridge under troubled water, right? We're perfectly fine. Let's be friends. You're the best friend I've ever had. Leave me alone. Friend contract. Please sign the contract to be friends. Meet you at the playground. I'd rather not. Because Clayton is not entitled to an award of any fees at all, it is not necessary to determine whether the amount requested is reasonable. However, if that issue was considered, it is clear the fee sought by Clayton's counsel is not reasonable under the controlling standards. So what they're saying is we shouldn't pay him anything, but they are still asking for too much. A lawyer shall not make an agreement for, charge, or collect an unreasonable fee. All right, so I guess they're accusing Woodnick of charging too much money. So they have the factors. The affidavit of Clayton's lead counsel, Woodnick, fails to mention, much less address, any of the controlling factors. Indirectly on pages 3 to 4 of Mr. Woodnick's affidavit, he provides some background biographical information, which includes some volunteer work and teaching work. While certainly laudable, nothing in Mr. Woodnick's affidavit supports his claimed hourly rate of $650, which is nearly double the average and median rates for family law attorneys in Arizona. So there it is. The average family law rate in Arizona is $329. And he says, Woodnick says, I've got a pedigree. I've been in the game for a long time. I charge double that. Undersigned counsel is currently serving a 3-year. So the point is underscored by the fact that Mr. Woodnick's stated rate is indeed only $325, as listed in the attorney roster maintained on the Superior Court's website. Again, I don't know what this means. I don't know if that hourly rate is for initial fees and it goes up. I have no idea. To be sure, just because $329 an hour is the average rate for family law attorneys in Arizona, and just because Mr. Woodnick advertises his rate at $325 does not necessarily mean that $650 would be always unreasonable for a lawyer with suitable experience, skills, and qualifications. However, nothing in Mr. Woodnick's affidavit supports the amount he requests, nor does he demonstrate that he is entitled to double his normal rate in this case. Yeah, I don't know. I mean, I charge anything from $20 to do a stand-up show to $8,000 for, half an hour's worth of work. Really depends on, or I'll do it for free if I want to. You know what I mean? It's like, it really depends on what people are willing to pay. Among other things, Mr. Woodnick makes no reference to any courts ever finding that $650 an hour is a reasonable fee, given his specific experience, reputation, and ability. A diligent search reflects that despite his 20-plus years as an attorney, Mr. Woodnick has never participated in any matter resulting in even a single published or even unpublished legal ruling in any court, anywhere in the United States, either at the trial or appellate levels. A search for Greg Woodnick in LexisNexis literally produces 0 results. Nothing. By comparison, he's like, search my name. You'll see YouTubers talking about me. They look at my shorts and my calves and things. By comparison, during a career of similar duration, undersigned counsel has participated in hundreds of matters across the country, including numerous high-profile cases. So he goes back to S-ing his own D. I wonder if he could get himself pregnant by S-ing his own D, or at the very least could go see a chiropractor for possibly hurting his neck. So there it is. He shares all of the noble times he's been Googled. To be sure, the existence or non-existence in Mr. Woodnick's case of substantial trial and appellate experience does not, standing alone, determine whether an attorney's fee is reasonable. The failure of counsel to demonstrate any basis for an hourly rate that is nearly double the average prevailing rate for family law attorneys in Phoenix is dispositive. The court cannot and should not find the fees requested by Clayton's counsel are reasonable, not because the fees are conclusively per se unreasonable, but rather because counsel has failed to meet his burden of showing the fee meets the requirement. My guess is Woodnick knows what he's doing here, and his fee is provable. But again, even if they change the fee to $350 an hour, most of the charges within this are Isabel and Deandra, who I think are back in the $150 to $350 hour range. So it's not, so again, I'm pulling numbers out of my butt here, but Woodnick probably accounts for 10% of the billable hours. So most of the billable hours is already factored in at a lower rate. So I don't think that would change the amount so much. Maybe it would go from 155 to 125. I don't know. Anyway, they go on. It seems to be that they share a lot, and then he signs it. And then we've got, I guess, exhibits. So there it is. Exhibits, average base salary. Boy, YouTubers are making more than this. They're kicking your ass. Hit the like button. Look, hey, any job that you want to do, I think is a noble job. If you want to flip burgers, I say flip the hell out of those burgers. I'm not going to shame you if you want to be a lawyer, an astronaut, or if you want to work the front desk at a Comfort Inn because you like saying hi to people that are there on business trips. I don't care what you do. I say take pride and do the best you can at what you do, and enjoy life. That's what I say. If that means being a YouTuber or a podcaster, by all means do that. Unlike Jingy, our goal in life is to spread as much love as possible, to be quite honest. It's not to knock anyone or rip anyone apart, but you got to do what you got to do in the pursuit of justice. And we've had to rip apart fraud. We've had to rip apart faulty medical documents. We've had to rip apart faulty ultrasounds. I haven't covered this case in weeks, and I got my fastball down the middle of the plate, mid-90s, and we will be here chucking fastball after fastball until this thing is done. And if any moles pop their head out of the ground, we are going to get the hell out of them, metaphorically, because we are in support of the truth. And I don't care if that means we make a buck or two on YouTube. All right. I've got extra content coming your way if you're still listening on Patreon. Today, I'm going to share with you guys on Patreon, quietly, I'm going to share with you guys the documentarians and where they are in getting this documentary produced, because a big development happened in the last couple of days, and I'm going to share it with you guys on Patreon at patreon.com/Dave Neal, because even though the story may be coming to an end, telling it to a global audience has not, and we will be here for that ride. We'll be back with more content right after this.